Hey everyone, welcome to today's Explainer. Think of me as your senior mentor, and today we are going to build out your legal toolkit. Now I know that if you're a non-law student, navigating the world of contracts can sometimes feel like trying to read a foreign language. But don't worry at all, I'm here to guide you through it at a comfortable, steady pace. Today, we're zeroing in on one absolutely crucial question. What exactly happens when a promise is broken?
Before we really dive into opening our toolkit, I want to quickly mention that this explainer was created by Zuramazun Salinan, a senior lecturer at UiTM Chuangan, Johor. It's always great to know we're building our knowledge on a solid academic foundation right from the start.
So here's our roadmap for today's study session. We'll look at when promises break down, financial fixes through contract damages, forcing action with specific performance, stopping harm via the injunction, fair pay using quantum meruit, and finally, choosing your legal remedy. Let's get right into it.
Part 1. When promises break down.
So when a business agreement just falls apart and someone breaks a promise, we call that a breach of contract, and you're going to need a legal tool to fix it. The absolute very first tool in your kit, it's called rescission. Think of rescission as the ultimate undo button. If a party severely breaches the contract, you have the absolute right to just rescind or terminate the whole agreement. You're basically stepping away from the broken promise and canceling any future obligations. It's really the cleanest way to cut ties when things go south.
Part 2. Financial fixes, otherwise known as contract damages.
But what if just walking away isn't enough? What if you actually suffered a real loss? That's when we pull out the most common fix, contract damages. In the legal world, damages is really just a fancy word for money. The standard form is called substantial damages. The whole goal here is incredibly simple, to put the innocent party, the plaintiff, right back in the position they would have enjoyed if the contract had never been breached in the first place. Imagine a contractor, let's call him A, who is hired to repair B's house. A gets paid in advance, but does a genuinely terrible job. B is now totally entitled to recover the cost of making those proper repairs from A. The money basically substitutes the loss.
To put a specific legal lens on this, under Malaysian law, these substantial damages are formally known as damages arising naturally under Section 74(1) of the Contracts Act. But wait, it doesn't stop there. There are also special damages for very specific losses you might sustain. Think about a famous singer who bails on a concert contract. The venue owner wouldn't just be out the standard fees. They can actually sue for the loss of profit they expected to make that night. The law really tries to cover the natural, foreseeable financial fallout of a broken promise.
Now what happens if a rule is completely broken, but your wallet isn't actually hurt at all? That is exactly where nominal damages come into play. This is basically a tiny token amount awarded to the plaintiff. It's kind of the court's way of saying, yep, the defendant totally breached the contract, you were right, but since you didn't actually lose any real money, here's a symbolic little token just to acknowledge the foul play. To make this super relatable, let's look at an everyday example. Have you ever ordered a Domino's pizza and it arrived late? Their guarantee was broken, which is technically a breach of contract. But, you didn't suffer a massive financial crisis just because your dinner was 30 minutes delayed. So what do? They hand you a voucher for a free regular pizza on your next order. It's a small token that acknowledges they messed up without needing a massive cash payout. That right there is the exact spirit of nominal damages.
Okay, swinging to the complete opposite end of the spectrum, we have a super rare tool called exemplary damages. With this one, the sum awarded by the court is way, way bigger than the actual financial loss you suffered. Why in the world would a court do that? Well, sometimes a breach is just so severe, so shocking, or so intensely damaging to someone's reputation that standard financial math just doesn't cover the sheer harm caused.
Take a look at this newspaper clipping, for example. It's about a ditched bride who was left high and dry just hours before her wedding. In cases like a breach of promise of marriage, the damage is absolutely not just about the cost of the wedding invitations or the catering. We're talking about massive emotional distress, intense public embarrassment, and real reputational harm. So in those highly emotional, extreme scenarios, exemplary damages step in to provide a much larger, frankly punitive, payout.
Part 3. Forcing action with specific performance.
Sometimes throwing money at a problem just doesn't cut it. You don't want cash, you just want the other person to do the exact thing they promised to do in the first place. This is when we reach for specific performance. It's a really powerful court order that literally compels the party at fault to carry out the contract just as it was originally written.
The judge is essentially stepping in and saying, look, you made this specific promise and there's no way around it. You are legally forced to perform it.
Let's make sure we're totally clear on the difference between these first two heavy hitters. Damages provide financial compensation to cover a loss. Simple enough. But specific performance is about forcing the actual fulfillment of the contract. A court will usually only grant specific performance when monetary damages just aren't an adequate relief. Say you are buying a rare, one-of-a-kind painting and the seller suddenly backs out. A pile of money doesn't help you buy a unique painting that doesn't exist anywhere else, right? So you ask the court to literally force the seller to hand over that exact piece of art.
Moving on to Part 4, Stopping Harm with the Injunction. If specific performance is the play button that forces action, our next legal tool is definitely the pause or stop button. We call this an injunction. An injunction is a strict court order designed to restrain the doing, the continuance, or the repetition of some wrongful conduct that goes against the contract. It's highly preventative. For instance, if an employee leaves a company and tries to leak highly confidential trade secrets to a competitor, which totally violates their contract, the company wouldn't just sit back and ask for damages later. They would immediately ask a judge for an injunction to stop that former employee from spilling the secrets before the real damage is even done.
Part 5. Fair pay, also known as quantum merit.
All right, we've arrived at our final major legal remedy. It's got a fancy Latin name, but the core concept is incredibly fair and straightforward, getting paid for the work you've actually done. The term is quantum merit, which roughly translates to as much as he has earned. It's basically a claim for reasonable remuneration or fair pay for work that's already been completed. We typically pull out this tool when one party suddenly abandons or just flat out refuses to finish the contract. If you painted half of a guy's house before he unfairly canceled the job, you absolutely still deserve to be paid for that half. You use quantum merit to demand that reasonable pay.
Let's look at a really fascinating legal application of this. In the case of Craven Ellis versus Conans Limited, some work was performed under a contract that actually turned out to be completely void, meaning it was legally invalid right from the starting line. Now, you might be thinking, well, no valid contract means no pay, right? Actually, scratch that. That's not how it works. Under quantum merit, the court decided that because the work was actually performed and the company genuinely benefited from it, the worker still had the full right to claim reasonable remuneration. So fair pay for fair effort, regardless of a massive paperwork glitch.
Part 6. Choosing your legal remedy.
Okay, we've officially explored the entire toolkit. But honestly, a toolkit is completely useless if you don't know which tool to grab when a problem actually pops up. So, whether you're facing a tough exam question or navigating a real-world business scenario, just use this simple step-by-step checklist. Step 1. Was there actually a breach of contract? If yes, and you want out, use rescission to terminate it. Step 2. Was there a financial loss? If yes, go for substantial damages. If there was a breach but no real monetary loss, nominal damages are your friend. Step 3. Is money just not going to cut it and you really need a forced action? That takes us to Step 4. Select your specific remedy. Use specific performance to force an action or hit them with an injunction to stop one.
To wrap it all up, here is your master cheat sheet. Rescission totally undoes the contract. Damages fix the financial hole. Specific performance forces the promised action. An injunction stops the bad behavior right in its tracks. And quantum merit, that ensures fair pay for partial work. If you keep this simple table locked in your mind, you'll be able to categorize literally any broken business agreement and instantly know which legal fix to apply.
I want to leave you with one final provocative thought today. Knowledge is really only power when you know exactly how to apply it. Imagine walking into work tomorrow and your biggest business partner completely breaks their most important promise to you. The thing is, you aren't helpless anymore. You've got a toolkit. So, which legal tool would you reach for first? Think about it. Apply these concepts, and you'll quickly realize that the law isn't some impossible foreign language after all. It's just a set of really logical solutions. Thanks so much for joining me on this explainer. Keep studying smart, and I'll catch you in the next one.